Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. This is where we discuss domain disputes and legal issues in the domain name industry. There's 3 hosts to this show. My name is Todd Ryan. My co-hosts are Jeff Neuman and David Michaels. Let me first say hi to my co-host Jeff Neuman. Check his microphone. Hey Jeff, how's everything going today? I thought Jeff was, no wonder. Jeff's not up here on stage. Okay, smooth as silk on the opening. All right, let me get Jeff up here. This ought to be easy. We've only done it 5.5 years now. We're going strong. See. Oh, I see Jeff now. Looks like Jeff is a co-host. Jeff, let's check your mic. What's going on? No, that's a thumbs down from me. I see your mic's open, but I don't see any, can't hear anything. Let's see. Recapture. All right, well, thanks for joining us, everyone. We'll get this thing rolling here. Just a second, we're already streaming live on YouTube. Welcome if you're listening on Spotify and the replay and Apple Podcasts. Yeah, so we have, okay, so you guys can all hear Jeff? Just I can't? Okay, sorry. Let me leave and come back. Let me refresh this baby.
Yeah.
Fantastic. Okay, fantastic. I'm back and I could hear you there. Try it again, Jeff. Let me just test your mic. Damn, once again, it's not working for me. It was working for a second. Let me press one more time.
Sudden.
Yeah, let me try to fix this. I'm going to go on another browser. Be right back.
Strings, which I guess they can. There's no harm at this point for doing sense for
Well, that was
us to
weird.
have hold music like that.
Yeah.
No, I think it makes sense for applicants to speak to each other. I think if they're once reveal day happens, if they want to withdraw, they only have a very short amount of time, and if they do, they get a good part of their money back, but still they lose a good part as well. So even if you get 60 something percent of your money back, you're still losing tens of thousands of dollars. So I think it's a good thing for applicants to be talking now. But that question remains to be seen. Todd, are you back on?
Yes. Can you hear me now?
Yes, we can hear you. We heard you before.
Oh, yeah. Okay. See, I just couldn't hear you. I don't know if it was Safari. I'm on Chrome now. But anyway, I see David was taking the month off of August. I want to say our the co-host David Michaels. David's here. I invited him up if he's free. Does want to talk. Today we're gonna be doing sort of switching it up a little bit. We're going to cover our UDRP case. This is sort of a format we're going to go on here on out. If there's anything that's really newsworthy, we may touch on it at the beginning and the end, but I thought we'd do our single case, which is much easier than doing 2 or 3 cases. So do our UDRP dispute first, and then go to our topic, and our topic today is really registering a domain name that includes a company name. But we're going to touch on, fanciful type names, descriptive names that companies name themselves, and then even a little bit about fair use. But really just touch on that topic, and then any question and answers at the end if anyone has any. So really trying to make it a bit simpler. And what I mean by that is just have one case, so it's much easier for us as the host. We can focus on one case and then have a topic that I think is more interesting to some of our listeners, and then have a Q&A. Before we get rolling, Arif joined us on stage. Arif, what did you have to say?
Hey guys, yeah, I just came on to give somebody for Jeff to talk to while you were figuring your stuff out. So I'll let you guys keep on going. I do have a couple of questions about the next round, but I mean it's not really too important. You guys get to your stuff, and if there's anything, I'll speak up at the end, or when you drop out, I'll jump in.
Yeah, Jeff, we're going to definitely speak about the next round. I think we'll revisit that, probably every other week, because it is so interesting. And I say so interesting. Okay, so a lot of companies are, you were talking about it, making public their announcement. And did you mention why you think they're doing that? Is it to really basically engage with each other before reveal date? Because ICANN was clear after reveal date, you can't talk with each other, but unclear before that. So was that your thoughts? That's why people are doing that?
Yeah, I think some of them are also seeking funding, so they're making their intentions known, their business models in theory known, and others are probably trying to scare other applicants, I guess, to get them to withdraw. Not sure it's going to work, but you have right now there seem to be the two largest seem to be a Chinese company that applied for. Well, it's unclear, but they list 323 strings on their website. And then you have what used to be Nova Registry called Freedom something Group. They applied for over 100 strings. So those seem to be the two biggest applicants at this point that have disclosed. But there are others that have disclosed that applied for 10, 12 strings, some only a few strings. We'll see.
Yeah, the LFG group. I was listening to Vaughn on the D&W podcast. You guys check that out. And he mentioned, listen, so we set up one organization, and it was not easy because it was so many applications, but much easier. Basically, he did say they got them all in, and it was basically because you set up one organization and you share your financials, what you need to share there, and then they just started going through the applications. But it sounds like, and I believe they paid for all theirs. We don't know. There's a lot of applicants who still have, really until tomorrow, some even a few days longer if they got their invoice past that the 12th. So ICANN is going to, during reveal day, obviously let us know who not just applied, but who paid, and we'll see what's going on. But it is interesting. A lot going on, so don't need to talk about it really every week, but I'm not going to wait until reveal day. So check our outline at dnlshow.com/outline, and you can see like this week's topic, this week's domain dispute we're going to cover, and then next week, depending on what happens this coming week, we're going to be revisiting this, this round of GTLD applications. So the very first thing I want to touch on today, well, I'm going to revisit it at the end as well, but there was a legal discussion at Domain Summit. I saw Igor was hosting today, as a matter of fact, so it was probably early today since it's now Tuesday evening there. But interesting. I look forward to having Igor on to let us know what kind of legal discussion they had at Domain Summit. And Igor was the moderator there. I'm just always interested in hearing different legal discussions. Some folks aren't interested in the legal discussions. All right, that's why we have a show on Thursdays called the DNX Show. It's for domain investors. We seldom talk about legal issues there. I mean, we touch on them if they come up, but not like this room. This is about domain name law. So thanks for being here. And hopefully there's going to be a nice session at NamesCon this year that has a question and answer session for the lawyers. I haven't seen it on the outline or their agenda just yet, but I know they're considering that. So wanted to mention that. Let's check David's mic. I know David was taking most of the month off, but this topic I put on today, I know he just couldn't resist. Hey, David, what's up?
Hey, Todd. It's almost the end of the summer, so I just thought I'd pop in for a few minutes to see what's going on, and still working on the simulcast app. So it'll be ready soon.
Yeah, and that will be helpful. David's working on an app that really evens out the audio. We all use different equipment. You see, I even had issues today. I'm surprised you guys, everybody could hear me, everybody could hear Jeff. I couldn't hear Jeff. But many times, and I do listen to the, or monitor the replays, and I see, sometimes I'm amazed at how the audio sounds okay, and then sometimes it's just terrible. But anyway, David, we're going to blow through this first case, not too fast, but the topic I think is interesting for all of our listeners, domain investors at that. The case we're going to cover today, well, I didn't finish when I was mentioning NamesCon. I want to also mention tomorrow, and I'll mention it at the end. Tomorrow, there's an ICA social call. So you should have got an email if you're an ICA member, but be sure and join us tomorrow. A lot of great topics and things we're going to discuss about NamesCon, some things that ICA is going to do at NamesCon, and then also the annual meetup, and then other topics, nothing off limits. Going to make some announcements, so be sure and join the ICA social call tomorrow. That's 9 a.m. Pacific, noon Eastern, and then hopefully we'll get lots of folks from over in Europe because it's still early for them, 5, 6 o'clock. All right, today we're going to start with our first case, and I think it almost goes along with our topic for today, but the domain is playboyvacation.com. And interesting, I think we all would recognize who the complainant is in this case, and they're a company, Playboy Enterprises International. So they're, I can't say known to be litigious, because certainly not. It seemed like more so in the, back 10, 20 years ago when they were more of a popular company, and so we'd see court cases, Playboy claiming people are infringing on their trademark. And we would see plenty of UDRPs too, of saying, hey, this person's cyber squatting. And I didn't look through UDRP.tools, which is a tool we use a lot, to see how many cases they've won, how many cases they filed total, and their success rate. But in any event, Playboy Enterprises was the complainant in this case, represented by a law firm out of Illinois. The respondent, Peyton Kane, represented by Zach Muscovich, Zach, general counsel of the ICA. Well, the domain name playboyvacation.com, somewhat descriptive. I didn't know until after reading the case. Of course, Playboy Enterprises owned playboyvacations.com. And so that, interesting, because you could see the complainant trying to make a case for, typo squatting, like, hey, we operate Playboy Vacations, this is without an S, and so on. They didn't make that case a strong case with that, because they had, the defense Zach had brought up on behalf of the domain owner, they hadn't used that domain name since 2012, and this domain owner had registered this name in 2014, Playboy Vacation, and offered a service on there, and it's really sort of like adult vacations. Just so I could understand more about it, I did book a couple reservations, and I have a great trip scheduled for my birthday, September 7th. Okay, so anyway, it interesting. The website does resolve now, playboyvacation.com, but at the time this complaint was filed, it looked to me, and Jeff, I know you looked at the case as well, it looked to me like they must have contacted the host, I'm talking about the complainant, contact the hosting company and probably said, hey, they're infringing on our copyright, and requested a DMCA takedown. Apparently the host must have done something like that, because the website was down at the time of the filing, so it didn't resolve. Now it resolves again, and it resolves to playboyvacation.com, and it says, hey, we have, adult vacations for folks if you're in the Dominican Republic or you want to, arrange a trip, arrange a vacation. So it's an interesting, interesting business. And this 3-member panel, I was going to say, had to consider, was this legitimate business? A lot of facts in the case I can bring up, and I will. But first I want to go to you, Jeff. What are some facts in this case? Being a panelist, playboyvacation.com, I'm sure you would already know who's likely the complainant in this case, and then let's slow it down a little bit and tell us about some of the facts that came in on the complaint and then from the respondent.
Yeah, sure. So, from the respondent's perspective, the respondent, as you said, represented by Zach, who's listening, made the case that look, we have been using this domain name since 2014, which I believe at the time either the complainant hadn't been using it or it hadn't used it in a couple of years, or sorry, hadn't used the Playboy Vacations plural in a couple of years, or that it hadn't been using it. And so the respondent's basically saying, look, we've been using this name for an actual business. We have a certain amount of revenue. I think it was like maybe close to 2/3 or 3/4 of $1 million in revenue. And so we're a real business. And if anything, first of all, we're using it in its generic sense. The term Playboy is not just significant for a brand, but actually has a dictionary meaning and for a type of person or a type of uh, it's got a general dictionary definition, and that's the way they're using it. They don't use the complainant's branding. They don't use the coloring. They don't use the logo or anything like that. And it basically made the argument that if anything, this is a case of trademark infringement with live businesses, and this is not appropriate for a UDRP um, to finally resolve this without having a full evidentiary hearing and cross-examination of witnesses and basically a court case. So they're saying that this is beyond the scope of the UDRP. And interestingly enough, I mean, you had all the panelists, and one of them being Dawn Osborne, agree that yeah, this is um, the complainant did not, well, a couple things. The complainant did not succeed in proving that the respondent, the registrant, did not have right or legitimate interests in the name. And because the respondent didn't, because the complainant didn't meet that burden, it can't move forward. But it also said that made the argument that look, even if even if the complainant showed like one instance of infringement, that alone is not enough for a finding of registration and use in bad faith. So I think there's a lot of good things that come out of this case. What I found really interesting, and I'd love to ask if Zach was surprised as well, there are no, with the exception of a couple cases cited for the premise that um, uh, where is it? There's one that a single instance, the complainant did not identify a single instance of actual confusion, and they cite to a couple cases there. There are no cites of any cases in the rest of the opinion, which I'm a little surprised at, because there's plenty of principles here that are supported by precedent and cases out there, but um, either they couldn't agree on what the cases were amongst the panelists, or they just, I don't know. To me, it's very odd that there's so few case citations or even citations to white, but there's a couple to the overview, but not even on kind of the main points of this decision. So I'd love to know from Zach if he was, surprised at the lack of case law that was even mentioned in this.
Yeah, and I don't know how much, right, how much Zach included in his response. Sometimes I get confused because I know you and Zach are both, many times represent respondents like Zach did in this case, but also as panelists. So, right, wasn't even looking at that, Jeff, about the minimal citations made by both sides, complainant and, well, respondent. We don't know. Maybe the summary didn't include them. David, did you take a look at this case, or did you? No, not for today.
Yeah, I did. I
Okay.
looked at it. I wasn't surprised the Playboy sued. It took them a long time. I remember when they sued Terry Wells back in the late 90s, and that went to the Ninth Circuit Court of Appeals. and it was ruled Terry Wills that was using Playmate in nominative fair use. But in this case, it's not necessarily nominative fair use, but it's being used in a dictionary sense. I looked up the history of the word Playboy. It had a different meaning in the 1800s, and then there was a book in 1907 that, you know, uh, made out a Playboy to be a guy who was more of a traveler, talker, and then it slowly evolved into a womanizer, and eventually in 1953, Playboy magazine or Enterprises decided to adopt it as their brand, but they adopted a dictionary word that was already, being used by people to describe the type of their clientele that would actually subscribe to their magazine. So that's what I saw in the case. I wasn't surprised about the decision. Um, they talked about, oh, what their business is illegal. Well, is it? Is it illegal in Dominican Republic to have girls? And no, they're not prostitutes. So what is illegal about it? I don't know. I don't even know what the legal age is in Dominican Republic. I've never been there. So, but that's what I saw in the case. So I didn't see any type of bad faith. In fact, they had an ongoing business. They say that they had $650,000 a year in revenue. I'm sure that varied by the year. And yeah, I took a look at the website, and the girls do look quite young. That's the slider, the photos that go across. So yeah, they're all hot. We'll see. Anyway,
I could,
that's
yeah, I
that's
couldn't
my
tell by
take
their
on it.
butt, but anyway, that was the opening. But no, interesting. Yeah, he said he made 650 grand over time. So that tells you, and I guess they submitted, well, I mean, they must have submitted sufficient evidence of these revenues of the revenue. And I thought, one thing that was interesting, there was contact between the complainant and the respondent. The complainant did reach out and say, we'd like to buy the name. And the respondent said 12,000 whatever pounds. And I know that's about 16,500 US bucks now, because I buy a lot of horses in Europe and I know how to convert anyway. So that's, I'm thinking if they made that much money, but then again, over that much time, it's not a lot. Why would they be willing to sell the name, especially, but then again, they probably thought, hey, we can use any name to, take care of this business. Maybe they got more in their arsenal. Maybe they have other names that they could use. Interesting, right? Playboy always was, like when you first said, David, the first definition, traveler, this worldly person, and then it got more into like a player, right? And then that's how Hugh Hefner, I think he thought he was a playboy, and hey, close enough, right? I mean, he did it. Anyway, he's, gone. Anyway, so I think that was the image he was trying to purvey. I don't know if that's the right word, could care less. But anyway, so there were, like I said, the Playboy vacation, they were offering a legitimate business. Zach positioned it as, if Playboy feels that there is a trademark infringement case here, then whatever, take it to court. But certainly not a clear case of cyber squatting. Getting to that third element of bad faith registration, they mentioned, we bought this for this use. We've never reached out to the complainant. And one, we have since 2017 put on the site a disclaimer that no relation to Playboy Enterprises or Playboy or anything like that. And as Jeff mentioned, didn't use the rabbit ears. So I think everyone knows Playboy does have a different meaning. I think, doesn't also has a meaning in addition to the magazine. And the key there was, I think Playboy's trademarks didn't really include travel and vacations in that area. So that was definitely beneficial to the respondent's case. And it was a 3-member panel. I can't imagine. I mean, sound like 3 different people to me. Flip Van Dam. No, Flip Van Claude. What was it? Let me see. Flip Jean-Claude. And Alan Limberry and Don Osborne. So Flip was the chair in the other two. Oh, Flip Jean-Claude Petillon. Anyway, is that French? Gee, I guess. So three-member
Yes.
panel and decided to deny the complaint. So the domain owner gets to keep it. Now he's got his site back up. And I don't think the other facts, if you were interested in looking at this case, the reason I brought it up was because we're going to sort of transition right into our next topic, and that is you register names. So if you were a domain investor, I think you'd have a tougher time holding on to this name because this one, I think the strong legitimate use here played a factor in the decision. So if you just were a domain investor and you had Playboy Vacation, I think you could have a successful defense, but is being a domain investor as strong as in the minds of a panelist, a strong use of it, not as strong as an actual real business that's generating revenue. But so Jeff, and then did you, David, do you think if you were just a domain investor and you registered Playboy Vacation, would you pretty much try to have the same type of defense, but just replace this real business? I say this business that generated 650 grand with you as a domain investor who's just sitting on the name. Is it really the same defense, just replacing the use?
No, it's a lot more complicated. It's a lot harder for a domain investor. Um, but again, you'd have to. It's not unwinnable, of course, but you'd have to show, because you didn't have a lot of this case was because there was an operating business for so many years, and because they were real, and because there was no showing of passing off or impersonation in the operation of this business. If it was a domain investor, they would have to show that there's a connection between this name and others that they have in their portfolio, that it's indicative of the types of names that they go after. They'd probably have to be more concrete in showing that they weren't targeting the brand owner. I think one of the points this case makes is that, look, just because you're famous doesn't mean you don't have to show that there's been targeting or infringement or anything or passing off. It just means that you're famous, and that in and of itself is not enough to win a UDRP case. But it certainly would have more weight if the um, domain was for sale and it didn't, and the domain investor didn't have some good connection to that type of name and its portfolio. So I think it would be a lot tougher for just a domain investor to win this case.
Yeah, David, any thoughts on that? I mean, Jeff, right on there, basically a domain investor have to really show similar names and really be more proactive in showing I wasn't thinking of them purchasing the name from me at all. I was hoping, I don't know. What are your thoughts?
Aside from this particular situation, I would say that if there's only one trademark owner out there and it is a dictionary word and you're combining, it's a famous brand, you're running into a huge headwind. But if there are many companies with the same name, like if you go to Open Corporates and you find, say, a dozen Playboy businesses out there, that's a good starting point. But if you find a few hundred, then that's very good. If you find, at least 5 or 10 maybe trademarks globally, that would help tremendously for an investor. But if you're the only one, you're going to have a serious problem depending on the panelists, and you might lose that name, and it's not going to be pretty. So that's the issue.
Well, we're going to talk about registering a name that is a company name, and you have it in your domain name, and there's differences in that. Before we get to that, Raghu, thanks for joining us. What comment or question did you have?
Yeah, thank you, and thank you for bringing me up. I had a similar case, not a case, a situation in 2018. I had a single word called penthouse, Okay, not with the .com, obviously, some other extension. And the purpose of that name I took was for real estate purposes. And guess what? I got a letter from from the Playboy or Penthouse people simply asking me to drop this. And you know what? I did. I did. I don't know why I did. I today I would have done that. But penthouse, I still believe it is a generic term rather than claiming as a trademark. And I know it's a magazine. I still have a collection of that magazines. But penthouse to me, it is still a real estate market as well. And I don't know. They didn't go through UDRP, and simply they asked me to drop this name, and I did. So I just wanted to let you know that. I don't know, penthouse, would you able to fight back or not? You know, just because of you were talking about it, so I brought this up.
I think
Yeah,
even
if you're a real
easier.
estate
Yeah.
agent, that's an easy one to win because real estate agents sell penthouse units all the time. That's definitely
That's right. That's right.
trouble term.
I know. So simply they sent me a letter, and next thing is I did is I just dropped it. I let it go.
I think a lot of domain investors, I mean, over the years, we've got letters. You don't want to, you don't know what the name is worth, especially in another extension if you're asking a lot for it. You just don't want to get involved in anything. And Ragu, many times that's still the right decision, even though you don't like somebody saying, "Hey, you can't park there. That's my space," and you're like, "It's not your space, and it is legal. I could park there, but I don't want you to, cause me problems." So
I know, but Todd, I still believe if, let's say, if I own that name today, and just like this case, I don't know who won. The complainant won, or what happened? Transfer happened.
the domain owner won. I would certainly fight it. If I owned
Oh,
Penthouse, I would
great.
fight it. But I'm just saying, many times
Yeah.
people think it's just I don't want to fight, even though I have rights to it. So I was just trying to make you feel like, hey, if you right now you know more, you certainly could respond back, and I think most people in this room would know. You can respond back and say, this is a generic word. This is a generic word, or this is a term used in many instances outside of your trademark. So I certainly have rights to it, and I didn't buy it because, the only way you'd be in trouble with the name Penthouse dot some extension is if as soon as you got it, you said Penthouse Tech, dot tech or dot AI or whatever. And you said, I know you guys are now turning the magazine into an AI. So I thought immediately of you, and I want to sell it to you. Well, then you can get yourself in trouble. You can get yourself in trouble with even, we're going to talk about very generic marks like purple.com. I think that's that mattress company. But if you registered a name Purple that didn't even have mattress in it, but you just immediately contacted them and said, I thought of you when I got this name and I want to sell it to you, that can be held against you in a UDRP, certainly, even if you didn't take any action yet, on the name to like try to
Yeah.
confuse people. So it really
You
depends on,
cannot. You cannot. Yeah. You cannot take yellow.com. I mean, it's a trademark. Yellow.com. Yeah.
for Yellow Pages. I don't know. Yeah, Yellow Pages, you mean? Well, okay. So getting to the topic of today, and we're only going to be here another 5 or 10 minutes. But David, I'm glad you joined us because it's a little bit about fair use. And so, Jeff, first I'll go to you. So when it comes to registering a domain name, if it's got, first let's talk about a fanciful trademark, meaning like Kodak. Okay, so a domain or a made up word. These are usually the strongest type of trademarks because it's a made up word. This company uses it for their business. But when is it okay to have a someone else's fanciful trademark in your domain name?
Well, I mean that if it's truly fanciful, think of them, like Kodak and some of the other brand, Coca-Cola, Pepsi. Then it's okay to have those in your names if let's say fair use or nominative fair use, meaning you're a supplier or you provide certain types of services but only under certain conditions, right? That you have disclaimer, you're not confusing the consumers as to the source of the information. But it's a lot fewer circumstances where you can have someone else's fanciful mark in your domain name. um, and not get into trouble than if you had a much more generic or descriptive name. So it's not that it's undoable. There are plenty of cases out there where, that are fair use or that are nominative fair use, but it's harder. It's much harder to establish.
David, what comments do you have about you can use that fanciful trademark, that name, if you're really just say Kodak Repair. I owned Chevrolet Repair for years, Pontiac Repair, and I really had, the car companies, they didn't like it at all. And especially as being a domain investor, and it was difficult since I really wasn't a Pontiac repair shop, that I was just a domain investor. They thought, but the point is, when how can you use Chevrolet Repair in a fair use way?
Yeah, if you're a Chevrolet shop, in certain jurisdictions, you can do that. That rule does not apply in every jurisdiction, so you have to be really careful. I think the Third Circuit doesn't allow you. I think there was a recent case saying that, well, the appellant lost, but I don't think he was actually using the domain name properly, or he wasn't using it at all in business. He was just holding on to it, and he appealed and he lost. And that was shared on LinkedIn recently. So it's very fact specific. So if you're actually an authorized or unauthorized agent or repairman for Maytag, and you have the domain name Maytag Repairman, um, you're gonna have some trouble there. But if you have a solid business, you might be able to win. But it's tough. But there's a lot of case law saying you're okay. Like in California, there's a Mercedes case, there is a Lexus case. I think there was another case in Colorado involving Mercedes brand. So it's okay in that respect. But other places you can use it on your website, but not in your domain name. That's a different thing. And if you're using on your website, don't include their logos. So if I was running a Mercedes repair dealership, I wouldn't use the Mercedes logo on my website. That's a big mistake. I've seen a lot of lawsuits over that.
Yeah.
And you know what? Sometimes they wouldn't have a problem if you just use the word Mercedes, but as soon as you put their logo on there, they sue you, and that costs you money. And if you can't afford an attorney to represent you, you're going to usually lose by default, because that's what judges do. When you don't respond, they just make you lose. They assume that you admit everything, and that's a problem. And so
Yeah,
I've seen
yeah.
damages
So,
in the range of $50,000 recently, so sometimes more.
so David, tell me something here. And this is the same topic. Um, when you park a domain name, and we are smart enough now. Remember when we used to park a name, and automatically the related businesses used to pop up on the parking page and pay per click type of thing. You remember that, right? And they make that as a base, as a case. Oh, you were infringing our business or whatever it is. So in this case of in Mercedes case, I'm confident too. I own AMG.ca. Nobody bothered me yet, and I had this name for day one. But I'm still a little bit afraid. One day, if I make something out of it, or I do something with it, and then what happens next? Okay, I'm going to be getting paper served by them. Mercedes, I don't know, but is a three-letter domain, AMG. You know what I mean?
Yeah, he knows what you
Yeah,
mean.
yeah. There's a lot of companies that use AMG out there, so it's fact specific, and that's the question.
And that's what we're going to get to.
And
Before we get to you, Brad, hold on. When he says fact specific, because it is true, if you just parked it Ragu and there was some BMW ads on there, well, then that could cause a problem, because then they act like, okay, are you using this mark and then attracting people to another brand, or even if you're attracting them to Mercedes. But David made a great point, and I'm going to get to you, Brad, is when he said it's like a shop. You can say we sell Michelin tires. Okay, but you are really, courts will say you really need to be limited on how you're showing your relationship to Michelin. So you could put in your ads that you sell Michelin tires, or even in your store, but to have your location or your store named Michelin something, that probably will not fly. So it's just like he said, using it in the domain name, maybe that's too much. On the website, so there is, it's fact specific on, and then quickly about, classic, this is like nominative fair use, where you're using a trademark to sell that product. What rights do you have? That brand. Classic fair use is something like, say, Sweet Tarts, for example. That's a brand of candy. Now, if you sell a candy and you put in your ad, Sweet Tart Sucker, we sell Sweet Tart Suckers, as long as you're just using it as a descriptive, it could fly, depending on if you highlight the sweet tart, maybe on the packaging, that could be a problem. So David's right. It's all about how are you using this, how are you using it in your, marketing, and if somebody else has a, like I said, a sweet tart, that can actually be a descriptive term for another candy. So you can use it. Got to be careful. Bradley, thanks for joining us. What question did you have?
Hi, thank you, Todd and Jeff and David and Raghu. I was getting back to the Chevrolet, and if you bought the name with Chevrolet in it, and you had a bad experience at the Chevrolet dealer, and you found a name with Chevrolet in it, and you wanted to create a site that said how you were abused by this Chevrolet dealer, would that be appropriate?
Jeff, you got a comment
Criticism
on that?
sites are
Go ahead, Dave.
usually okay, depending on the facts, but if it's authentic, usually get away with it.
Yeah,
Okay,
if it's authentic, if it's not just like tarnishing, yeah, you got to be careful. You got to be correct, and it, again, it's you can, but it's not always. What some people think is criticism, it goes a little bit over the line.
but so criticism is an appropriate fair use. But yes, obviously it could go over the line. And then another thing is that there's a difference between Chevrolet and Mercedes, because Mercedes is also a woman's name or something like that, right? It's used outside of the context of an automobile thing. And then one other thing I wanted to mention to maybe Raghu, I think, having AMG, maybe if you come up with your own, acronym that it
I do.
stands.
I do. I have 3 acronym of this. No
Oh,
issue.
okay.
No issue
Okay.
with that. Yeah.
Yeah, cool. Okay. That I just wanted to bring those up. Thank you.
Well, thanks. We're not going to be around much longer, but I wanted to welcome Ace to the stage. What comment or question did you have today, Ace?
Todd, great space as always. Happy Tuesday. Great to see you guys. David, Jeff, Bradley, Raghu, you guys too. Yeah, I have Todd, I had 2 questions for Jeff, if that's okay. As an ASP applicant in the 2026 GTLD, I just wanted to ask you guys, when exactly do the auction rules and the bidder agreement go out for public comment? And is there any organized channel for the supported applicants to file jointly? The bid credits value, does it depend entirely on the mechanics that aren't published yet?
So, to my knowledge, they have to pick a vendor first that's going to do the auctions, and I don't
Okay.
think they've selected a vendor. Then that vendor will have to work with ICANN to come up with the final rules. So I don't think we're going to see the rules until probably more towards the middle or end of the fourth quarter of this year,
Whoa.
just at the earliest.
Mhm.
And then it'll go off for public comment. It'll be just like a normal public comment on the ICANN site. And the bid credit, I don't believe is with applicants pooling their resources. I think it's individual to each applicant.
Brilliant. Yeah, that's kind of where I wanted to actually ask the question. So this is the most important one. If a supported applicant raises outside capital to fund an auction bid, do they jeopardize their ASP status or forfeit the bid credit? Like, where's the line between legitimate financing and like a prohibited arrangement?
Yeah, that was something that we brought up in discussions there. I think that they would not hold the raising of money for an auction, specifically for an auction, to hurt your ASP qualifications.
Hopefully. Oh my goodness. Okay, that's reassuring because this is my real main question regarding the bid. Is it in an ascending clock? Like, does the credit let you stay
Yes,
active as at the clock prices above your cash position, or does it only reduce the settlement amount?
it, well, that remains to be seen how they're going to implement it. My understanding was is that it would just reduce the amount at settlement. So you would just know when you bid that you'd only be paying what, three quarters or whatever the credit is. You'd be paying less than what the second price was, right? So you have a winning price, and the winner gets it at the second highest price. And then if an ASP candidate is the winner at that second highest price, then it's a discount off of that second highest price.
Oh, oh my goodness. Wow, wow, wow. Gentlemen, I'm so grateful for your insight and time. Todd, thank you for just giving me 2 minutes to speak with you guys. I've been following the show forever and feel much better now. Thank you so, so much.
Do you want my PayPal account?
Ragu, I'm your biggest fan, man.
Okay, thank you.
Hey, everybody.
Cheers, buddy.
Thanks for joining us, everyone. We really appreciate it. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. It's the Domain Name Law Show. Like I said, three hosts of the show, myself, Todd Ryan, Jeff Neuman, and David Michaels. Now, each week, we're just reviewing one domain dispute. We're covering a topic, a domain, sort of domain law topic, and then a question and answer session. So we're going to do that each week. We really appreciate you being here. One more time tomorrow at 9 a.m. Pacific, noon Eastern. There's the ICA social call that we're going to be talking about some, recent topics and some announcements. So look in your email for your ICA invite link. So, and if you're not already an ICA member, reach out to them. You can just go to internetcommerce.org and reach out and say, hey, I want to participate in this call. How do I do it? It can be your first meeting. But anyway, thanks for being here. Talk to you next week. And then, of course, join us on Thursday. Me and Josh are doing this domain name investing show. It's the DNX show, 10 a.m. Pacific, 1 p.m. Eastern, right here on X. Until next time, take care of yourself.